I'm Joel Fairbrother from Bow River Law in Calgary, Alberta. I'm an employment lawyer, and today I'm going to be answering the question, what should I do if Human Resources says there's a workplace complaint against me? So, workplace complaints against an employee in Alberta, they typically what happens if an employer is suspicious of bad behavior or there's been an actual formal complaint or an informal complaint made that someone else says you did something wrong, either that you harassed them or that you failed to do your job in some way. The employer is going to investigate. So the first thing that you should do, like so many of my answers to these questions, the first thing you should do is get an employment lawyer. But in the meantime, sometimes you have to appear at an investigation meeting right away. Sometimes if it's a small company, the owners will do the investigating usually. If it's a medium or large size company, usually they have human resources, or they'll bring in a third party investigator. The investigator will usually have a meeting with you. They will tell you what's going on in very general terms. And they will mostly just be asking you questions to see what your responses are to what someone else has told them. They might not tell you everything the other person told them. They might just be trying to see what you have to say. Then usually after that meeting or series of meetings, they might let you go back to work. They might put you on a suspension for a short time while they sort of try to gather the facts and decide what to do. They might ask other people questions. There are many things you can do to prepare for one of these meetings. One of the things that I would suggest is, you go in, and prior to going into the meeting, you have a list of questions. You say, I'd like to know what this is going to be about. I'd like to know if you can give me a copy of the complaint, stuff like that. Now, they probably won't give you a copy of the complaint prior to the meeting, but it's good to ask for it because it can, in some cases, they do provide it. And if they don't, then you may be able to use that later to say they tried to catch you more or less flat-footed, or they tried to, create a situation where you're unable to answer questions in the meeting because you're not prepared. So there can be uses to asking for those questions, even if they don't give them to you. Also, when you're in that meeting, or meetings, I should say, you should be taking notes. What commonly happens is there will be human resources or the owner will be taking notes. But if you don't take any notes, there's only one set of notes. That's not good. You should take your own notes as well, if you can. And even if you can't take them during the meeting, if you can take them right after, just so it's all fresh in your mind, that's good too. And then, there's a period of time they might terminate your employment, they might not, but either way, you're going to want to speak to an employment lawyer about that, because employers often say they have just cause for termination, for example, but in most cases they don't. And even if it's sort of on the line of maybe they have just cause, maybe they don't, in most cases that we can still get a settlement because the employer knows they have some risk in those situations. So I hope this has been helpful. My name again is Joel Fairbrother from Bow River Law.